To me, the bill is correct, right? Because it's a union territory, not a full-fledged state. Therefore, what you have is a diluted form, an asymmetrical form of federalism. What is pending before the Supreme Court is the validity of the ordinance and specifically two questions referred to the Constitution bench. That has nothing to do with what is being debated in the House, number one. Number two, this is for all the members of the House, and it has some importance so far as the relation between the judiciary and the executive is concerned. I would request all the members of the House to have a relook at Articles 105, 121, and 122. There is absolute freedom of speech in Parliament, and whatever a member says in Parliament cannot be questioned in a court of law. I do not find a similar constitutional provision restricting the debates in courts. What the courts cannot do under 121 is question the conduct of a judge in relation to a pending matter. The restriction that the House imposes on its own speech is self-imposed by the rules. And what do the rules provide? Mr. Chairman, sir, the rule says a member shall not discuss a matter of fact, which is a court pending before a court of law. It's not a matter of fact that is what is being debated. It's a question of law. It is not even an interpretation of law. It's on a debate on law. Now, Mr. Chairman, sir, so where as sub judice is concerned, the bill takes away 3A from the ordinance. To my mind, it's a perception, I may be wrong. To my mind, when 3A has been taken out of the ordinance and it is not there in the bill, the questions referred to the Constitution bench stands self-answered. Because if you read the order of the Supreme Court referring the matter to the Constitution bench, a copy of which I have got and I have read, my view is that the entire reference has been necessitated by the provision of 3A of the ordinance, which no longer exists. Therefore, it is the prerogative, the right of the members of the House to debate. The question of sub judice doesn't come. What the bill provides is diluted form of what federalism, because it's a union territory, not a full-fledged state. Therefore, what you have is a diluted form, an asymmetrical form of federalism. And the third thing is, does it violate any other part of the Constitution? The Supreme Court mentioned about triple autonomy. What you have under the bill is a modified form of triple autonomy. The bureaucrat is responsible to a lieutenant governor, who is responsible to the Home Ministry, who is responsible to the House. You have a modified form. If you want a full-fledged federalism, which today is a basic feature, though I have my own perceptions there, you can go for an amendment, for a constitutional amendment, and make Delhi a full-fledged state. Now, the most important thing, Chairman Sir, is Article 239AA, starting from 1 to 7, is not under challenge before the Supreme Court. Challenge it. That is not under challenge. Therefore, in my respectful submission, my contention, the bill is perfectly legitimately valid. But I fully support Mr. Vikas Bhattacharya, who has been a very close associate of mine. What is permissible need not necessarily be right. In the House today, parliamentary democracy compels members to vote according to party dictates. Fine, I cannot quarrel with that. It's a small section of people to whom you appeal to their conscience. To me, the bill is correct, right? My conscience tells me to do something, I'll do it. But if somebody disagrees, his conscience must be left free. Thank you. I am honored. I'm privileged.